Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution and this honorable court.
Good afternoon. We are here on case number 14-20-00831, Roque versus the state of Texas. Is everybody present and ready to proceed?
Yes, Your Honor. Crispin Linton, counsel for the appellant, Your Honor, here. Ready?
And yes, Your Honor, Kyle Jones for Appalachia, Brazoria County, state of Texas.
Okay, we can hear you, and I presume you heard me. So I see the appellant reserved 5 minutes for rebuttal. Is that correct?
Yes, Your Honor.
All right, you may proceed when you're ready.
Okay. Judge, this is Crispin Linton. I'm the attorney for Mr. Roque in this appeal. This is an aggravated robbery case in which Mr. Roque, my client, received a 40-year prison sentence on December 7th of 2020 based on an armed robbery that took place in Pearland on April the 7th of 2019. In my first point of error, I brought to the court's attention what we suggest is that the evidence is insufficient to support the verdict of aggravated robbery. And I'll list 7 different reasons. I believe that these reasons set out would show that a rational trier of fact would not be able to find the essential elements of aggravated robbery beyond a reasonable doubt. Number one, my client in his statement to the police said that he denied robbing Mr. Pham at gunpoint. Points 2 and 3, there was no courtroom identification by Mr. Pham of Mr. Roque, and no crime scene identification of Mr. Roque by Mr. Pham. A fourth point was that there was insufficient lighting at Mr. Pham's house for him to make a good identification anyway. Number 5, there was talk, Mr. Pham had mentioned that the robbers wore bandanas, but there was no bandana that was found on Mr. Roque when he was arrested that evening. A sixth point was that Mr. Pham, in his identification to the police, had said that the defendant, or the man that robbed him at gunpoint on his driver's side window, was wearing a black T-shirt and had long hair. But Exhibit 12 that was introduced showed that my client did not have long hair, and that the T-shirt that he was wearing, while it had some black in it or dark color, was almost covered entirely by a white figure of a woman on that T-shirt. So we believe that his identification to the police officer that night also backs up the statement that no rational trier of fact would be able to find him guilty of this crime beyond a reasonable doubt. And then lastly, the vehicle that was driven that night did not belong to Mr. Roque, the appellant, but belonged to the mother of one of the juvenile suspects.
Mr. Linton?
Yes, Your Honor.
When you've used the standard of rational trier of fact a couple of times now, is that the standard we're considering here?
In that Jackson versus Virginia, yes, Your Honor, that after viewing the evidence in the light most favorable to the verdict, that a rational trier of fact would not be able to find it beyond a reasonable doubt. That even
Go ahead.
That even if we viewed it in the light most favorable to the jury's verdict, these 7 points would show that a rational trier of fact would not have found it beyond a reasonable doubt. That his mere presence at the scene, the fact that he was hiding in the woods near where the truck had crashed into a light pole, is not enough.
Well, and I agree, the law says mere presence isn't enough under Jackson, but I assume your contention isn't that if you don't have a witness identify somebody's face, there are other ways to get an identification besides that, correct?
Yes, Your Honor. You could certainly look at circumstantial evidence or just the other evidence that was admitted during the trial.
And you wouldn't even need fingerprints, right? I mean, you could have descriptions of body shape and other things, that enough of that comes together that you have a legally sufficient evidence.
That's correct, Your Honor. Well, while it would be great to have fingerprint evidence or DNA evidence, that certainly is not required in order for the state to convict beyond a reasonable doubt. That's correct. So that is my insufficiency point, Your Honor. Did you have any other questions about that?
I may.
Okay, the next issue was the issue of lesser included charges, which is the point of error, the second point of error. The appellant during the charging conference had requested the lesser included charges of both unauthorized use of a motor vehicle and theft. And the judge denied it in this particular case. And we are stating that the judge erred in this decision in not allowing the jury charges of both unauthorized use and theft to be brought forward to the jury for them to consider, Your Honor. The state in its supplemental brief attached Williams versus State, a very recent opinion that has come out, I believe it was in May of this year, in which the court was stating that a trial court only errs in refusing an instruction on a lesser included if the specific evidence is manifest, or if the trial court errs in refusing an instruction on a lesser included if the evidence is manifest or it's obvious, or two, that the defendant in that charging conference has pointed out specific evidence that negates the greater offense but also supports the lesser offense. And based on the Williams case that came out in May, I would suggest that number one, first, it's probably manifest that there was evidence of both theft and unauthorized use. Mr. Roquet, in his statement to the deputy, had stated that he had fallen asleep after getting into the vehicle in Houston and did not awaken until after the armed robbery, the aggravated robbery, had been completed. So his statement negates the crime of aggravated robbery. And
is it evidence of a lesser?
The evidence of a lesser comes into play with the statement of the Deputy Snellgrove, who said that when they were doing an inventory of Mr. Roquet's property at the jail, they found $417 on him. And Mr. Pham had testified in trial that his wallet was stolen, or it was missing, and that there had been $400 in the wallet. And so this, in the state's argument, they're saying one of the reasons it supports an aggravated robbery is that there was $400 with my client, with Mr. Roquet. So I'm saying if you use that analysis, if my client testifies to an officer, gives a statement saying, hey, I'm asleep this entire time, I don't know what's happening until I'm awakened after the robbery, but a wallet is taken, or $400 from that wallet is taken, that there is evidence, maybe not a lot, but there is evidence of theft.
But that, if I'm not mistaken, that $400 was given back to your client. Is that correct? I mean, it was never returned to Mr. Pham.
When you said it was given back to him, it's my understanding it may not have been given back to the victim, Mr. Pham, but I don't know if it was ever given to my client. It may have been put on his books. I don't know what happened with it. But that is certainly true. I guess it could have been given back to him, but I don't know if it was or not. And there's no evidence I know of that it that it particularly was.
So under Williams, because this isn't a lesser as a matter of law. I mean, it's fact specific, correct?
Correct, Your Honor.
So what was the factual discussion below that preserved it as a lesser?
Well, on page 101 through 105 of volume 6 in the charge conference, Mr. Roquet's attorney states to the judge that he was going to get that theft could be anything from a theft of the car, theft of a wallet, theft of the cell phone, or theft of money. So the appellant's counsel makes this argument to Judge Gilbert on pages 101 and 102 of the record. And it is our belief that that is enough specific reference to the issue of theft as well as unauthorized use that it should have been included as a jury charge, Your Honor.
But there's no specific reference to the money saying this is enough evidence. The money I had and the money that was, that was taken, this is enough to do it.
Yes, my client did make a specific statement to the police about taking money. All he did was simply deny that he held up Mr. Pham at gunpoint. Thank you, Your Honor. I believe my time is up. Is that correct?
You're muted, Justice Wise.
Typical, sorry. Yes, the time's up.
Okay.
We'll take it up further on rebuttal. Mr. Jones, when you're ready.
Yes, Your Honor. May it please the court, opposing counsel. I want to start first by going into sufficiency, specifically identity, since that is what is specifically attacked in opposing counsel's brief. Then I'd like to touch on lesser includeds, and of course, I'll take any questions that the court might have. Justice Spain, I think you mentioned, of course, that mere presence is not enough for sufficiency, or I think as appellant's counsel states in his brief, just the fact that he was at the scene in the crashed truck and he fled was not sufficient. I think the record shows quite a bit more than that in the brief. I think.
And I just want to be clear. I was
Yes,
stating that as an often, stated doctrine by the courts that just because you're standing there where it happened is not enough to convict you with nothing.
Correct.
Okay.
Yes, Your Honor. But I did want to get into some of the other things that showed circumstantially, because as I think you suggested, circumstantial evidence in a criminal case is as probative as direct evidence. And here we have quite a bit of circumstantial evidence. There was a partial identification provided by the complainant, Mr. Pham, identifying some of the defendant's clothing that he later retracted. But the jury did hear evidence of that identification of the clothing. And I believe an officer offered an opinion stating she believed that the complainant was attempting to identify the appellant. That did come in as evidence. Also, there was
Jury heard a
evidence.
retraction.
I'm sorry, Your Honor.
Was the jury aware that there was a retraction?
Yes, Your Honor. And they
Okay.
could have weighed the earlier statement of the complainant as well as the later retraction and decided where to give deference there. There was also evidence of the defendant was identified as the first person leaving the crashed vehicle by an officer through the driver's side window. And the officer offered his opinion that it is likely that the first person out of a driver's side window would more than likely be the individual driving, even though that officer did not have any direct knowledge that the defendant was driving. As well, there was evidence, circumstantial evidence, that the defendant may have assisted in coordinating this aggravated robbery, in that he lived near the washateria where Mr. Pham worked, where Mr. Pham believed he was followed home. There was a case of beer discovered in Mr. Pham's stolen Chevrolet. He was the only adult, the appellant, out of the four people in this case, and a juror could have inferred that he purchased this case of beer, certainly. And there was also evidence, as I said, that he was the only adult amongst these juveniles, and that when he exited the vehicle, he actually ran with two of the juveniles into the woods. Now, along with all that evidence, we have some circumstances of guilt that support the guilt of the defendant and the verdict in this case in the light most favorable to the jury's verdict. We have possession of incriminating evidence. Not only was the defendant in a stolen vehicle that he was found in, that he fled from, but there was also property that was found in the stolen vehicle. There was the complainant's wallet. There was the complainant's cell phone that was discovered in there. And under Batiste and Bonner, those are Court of Criminal Appeals cases from the 1970s, but certainly those cases stand for the proposition that in cases where complainants have difficulty identifying someone in a robbery case, that possession of stolen property at a time and place near the robbery is sufficient to sustain a conviction for robbery.
And I
And
assume you're referring to the money in the wallet.
That too, Your Honor. I forgot to mention that as well, because that was recovered from the defendant's inventory, that he had $417 in his wallet, which was remarkably close to the $400 that was in Mr. Pham's wallet that was taken from him.
But it wasn't the same amount.
I'm sorry, Your Honor.
But it wasn't the same amount.
That's correct, Your Honor. But I think a reasonable inference could be made by the jury that it was so close that it was potentially a circumstance of guilt there. In addition to the possession of this property, and I will mention the Batiste and Bonner cases were mentioned by this court in an opinion written by Justice Wise in 2017 in Clark v. State, which was an unreported case involving another aggravated robbery. We also have flight. We have a couple of kinds of flight here. We have the flight in the stolen vehicle, which went up to speeds of over 100 miles per hour. And then when that vehicle crashes into a light pole, we have everyone running out of the car. We have the appellant and two juveniles going into the woods at that point, where the appellant hides for, I believe, over an hour before he is found. And then finally, I'd like to offer the appellant's implausible explanations as far as how all this went down. He claimed that when he was in Southwest Houston, that he got in the vehicle, that he was in there initially with the juveniles. And he claimed at that point in his oral recorded statement later that he blacked out, that he did not remember anything. And the next thing he remembered, they crashed into the light pole and he heard a boom, so that he wasn't awake for anything that happened in between there. His claim was that he slept through the aggravated robbery, that he would have slept through a high-speed police chase with lights and sirens, and that he would have missed all of that because he was asleep. There was officer testimony in which an officer stated it would be highly implausible that someone could sleep during all of that. I think the jury could have inferred that as well.
Even as a passenger, was that discussed?
Even as a passenger, Your Honor?
Yes.
I think the idea that you could be in the vehicle even as a passenger and sleep at that point, it would be highly improbable.
I understand, but we don't have any direct identification that he was the driver. We have the inference because of the way he came out of the car.
Correct, Your Honor. That's correct. And then also party coordination, both as the driver and as the other facts that I mentioned earlier. I do want to mention, because appellant states that there was no courtroom identification, that's not required in a case like this. I believe Justice Wise recently wrote a published opinion, Prince Warren Stone v. State, which was released in October, that once again affirmed that an ID is not required, that it can be proven through circumstantial evidence. And also, as far as saying that other factors outweigh the inculpatory facts, that the exculpatory facts outweigh the inculpatory ones, that was a decision for the jury to make as far as what they would decide in terms of the evidence that they received. They received all that evidence, and they ultimately made their decision that the defendant was guilty of aggravated robbery. And I think this is similar to a decision authored by Justice Hassan in State v. Green back in 2020. In that case, it was also suggested that certain exculpatory facts outweighed the inculpatory ones. And I believe what the court held was that ultimately that the court is to defer to the jury in a legal sufficiency analysis. And so in the light most favorable to the jury's verdict, it can certainly be upheld on the circumstantial evidence that was presented. I do want to touch on lesser includeds. Mr. Linton mentioned Isaac Williams v. State, which we filed a supplemental brief on. I do want to be clear about Williams. I believe there was a motion for rehearing that was filed on June 9th. And to my understanding, it has not been disposed of. So Williams, although I did want to bring it to the court's attention, is still a case that can be revised at this time. So I understand if the court is reticent to rely on that for a preservation argument at this point, since at least.
And I appreciate you telling us that, counsel. I'm not sure Williams is stating anything radically new.
Okay.
But I mean, I think the question would be is if it's a lesser as a matter of law, and and somebody says I need a lesser. I mean, aren't we done? I mean, we don't have to have a long discussion. I mean, the judge is presumed to know the law, correct? If it's I'm not suggesting this fact pattern is that, but I mean, if it is a lesser included offense as a matter of law.
Well, Your Honor, I believe under the Aguilar-Russo test, it's a two-step process. So first we determine if the lesser is actually a lesser included. Legally speaking, does it fall within the proof necessary to prove the greater? And then the second step is going to be the factual analysis,
Right.
whether this is I'm sorry, Your Honor?
No, I said I'm agreeing with you. I mean,
Okay.
the issue here is that we have the money in the wallet is circumstantial evidence of guilt. So guilt of theft?
Not guilt of theft, Your Honor. At least from our vantage point, what we're dealing with is a situation where there were two rational alternatives based on the defendant's statement in this case. The defendant did not take responsibility for anything. He stated that he fell asleep throughout the entirety of the criminal episode here. He only woke when they hit the transformer, the pole, and that he ran into the woods because his friends told him to. And so there is no set of facts here based on what, and I think appellant has stated he relies on his statement for the set of facts under which he would have been entitled to a lesser included. There is no set of facts under which he has raised the lesser included of theft simply because he was in possession of the money, because there's no evidence in the record directly germane to raising the lesser included, that he was not guilty of aggravated robbery, but was somehow guilty as a party or as a principal in terms of just committing the theft.
So hypothetically, had he not said that he was asleep and doesn't remember anything and on and so forth, would the circumstantial evidence of the money, take us a long way or get us there on a lesser?
I would say it would not, Your Honor, because there would still not be any evidence directly germane to raising the lesser included as an alternative to the greater and refuting or negating an element of the greater offense. Now, hypothetically speaking, if it was a situation where he said, well, I woke up and then they gave me some money and I knew that the money was stolen and I shouldn't have taken it, but I did. Then perhaps at that point, you would have some evidence directly germane to supporting the charge only of theft and negating aggravated robbery at that point. You would have affirmative evidence that was raised by the record. The evidence that we have in the record here is that the defendant, while he was in the vehicle, was blacked out and did not awake until it struck the light pole. And therefore, he could not have operated the vehicle intentionally or knowingly without an owner's consent, such that he would be guilty only of unauthorized use of a motor vehicle based on the facts that he's raised through his statement that he is relying on because he slept through it. There's no evidence in the record affirmatively showing that he was only guilty of the theft such that he was not involved in the aggravated robbery, but came into possession of the property afterward and was guilty of possessing that stolen property. There were only two rational alternatives here, ultimately. He was either guilty of aggravated robbery or he was not guilty of any offense whatsoever based on this evidence. And I believe that Clark, the 2017 case, is once again helpful. That was an aggravated robbery case in which the defendant claimed because there was a questionable identification that he was guilty only as a party or only as possessing stolen property. And I believe what the court said in that case was that he was not entitled to a lesser included based on the idea that the identifications were questionable. And that's similar to what appellant is stating here. He's claiming, well, because the evidence was insufficient to show that that I had a firearm or that I operated as a party in this case, then I was entitled to a lesser included because I just had the money in my possession. What the court said was it was not enough to disbelieve crucial evidence of participation in the robbery. And I think that's what appellant is suggesting in his brief, is that you can just disbelieve some of the sufficiency argument, or at least you can credit his arguments with regard to a lack of sufficiency and say that that entitles him to the lesser included. But under Clark, which cites to Bullock, which is a 2016 Court of Criminal Appeals case, that is not affirmative evidence. That's simply a lack of record evidence or a sufficiency argument. That's not enough to get you to affirmative evidence in the record. And are there any other questions with regard to lesser included? I would say with regard to the final two issues, since I have a couple of minutes, I believe in his third issue, which discusses jury disablement, I believe that was a firm case of where a court has discretion to make a decision The juror in that situation stated clearly and unequivocally, according to the court, that she could continue to fairly and fully perform her functions as a juror. And as far as revocation of the bond, I think ultimately the strongest point there is that it's pretrial confinement. And once the bond is revoked and once the verdict comes back, that situation is mooted entirely because you're no longer dealing with pretrial confinement. The defendant was sentenced to penitentiary at that time. If there are no other questions, I would yield my time back to the court. Thank you.
Thank you, counsel. Mr. Linton?
Yes, Your Honor. Judge, I'm sorry, I clicked my button now. Okay. In regards to what counsel had said, the evidence of guilt, the fact again that he is in a stolen vehicle in flight is to me just circumstantial evidence, because he has already made a statement to the police that he had been asleep that entire time. And so therefore, I just would move on to the lesser included, which is when the counsel said that he didn't take responsibility for anything. Actually, what he did was he just denied that he was involved in an aggravated robbery. And so his denial that he was involved in an aggravated robbery would not preclude the ability to have a lesser included on theft. Just because he did not take responsibility for the theft doesn't mean that there was not some evidence here to show that a lesser included would apply, Your Honor, whether it be theft or unauthorized use of a motor vehicle. And then lastly, on the point number 3 on the juror, it is just our belief that while it is the discretion of the court, the juror was red-eyed and upset, and based on the fact that her husband's grandmother had died. And we just believe that in a situation like that, that she may have told the judge that she could continue on with this trial, but just her mannerisms, her red eyes, and her being upset was such that the judge, his discretion was not done correctly and should have allowed the juror to be excused. So with that, that's all I have, unless y'all have any questions.
No other questions. All right. Well, thank you very much for your arguments this afternoon. Roque versus State is submitted, and we are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.